Pleasant good day to everyone. Now we are going to discuss a specific topics on the book 2 of the revised penal code on criminal law. One of the favorites in the board exam, which is the crimes against person. Okay? So crimes against person is found under title 8 of the book 2, beginning with article 246 up to article 266, but with the addition of one article, which is the rape, no, which is formerly the crimes against chastity, now transferred to crimes against person. Once more, this is Dr. Ariel D. Manlusok, okay, the director of the ADMRC. Okay, let's begin with the coverage. What makes up the Title 8 or the crimes against person of the Book 2 of the Revised Penal Code? There are two chapters, no, or sub-chapters. The first chapter deals with the destructions of life. And these are the articles 246, which is parricide. Article 247, the death or serious physical injury under exemptional circumstances. Number 3 is Article 248, murder. 4 is Article 249, homicide. 5th is Article 251 and 252, which is focused on deaths and injuries brought by tumultuous affray. 6 is Article 253, giving assistance to suicide. 7 is Article 254, illegal discharge of firearm. 8 is 255, infanticide. 9 is Article 256 to 259, which pertains to the provision on abortion. And Article 260, which deals with duel, and up to Article 261. That is the first chapter. The second chapter deals with the physical injury, which covers the Article 262, which is mutilation, Article 263, which is the physical injuries, up to 266, and the last is Article 266-A, which is the addition brought by Republic Act 8353, changing the nature of the crime of rape from crimes against chastity to crimes against person. Now, let's discuss them one at a time. Okay, destructions of life. Actually, I crafted a simple flowchart for easy understanding of how to analyze crimes against person. So, I'm not going to follow the order in the revised penal code. Instead, I come up with my own order in which this will make the reviewees or the learners identify easily which of the crimes against person is the more probable answer in a given situations. And these are what? Let's start with victims. Then from the victims, we can already identify somehow the crime or the felony specifically that was committed under the revised penal code. Okay? Very important that we should know who the victims are or who the victim is. Okay. If the victim is an unborn fetus, okay, you kill unborn fetus. It's not very important as to who is the killer. The important part here is only the victim. The crime may either be intentional abortion, unintentional abortions. Okay? There's also one kind of abortion, but this is not criminally sanctioned by law, which is the therapeutic abortion. This is a practice made in the field of medicine when there is a threat between the two, the parents and the child, no, or the unborn fetus. Somehow, the husband or the couple may decide as to whether they will sacrifice the fetus so that the mother will survive because of the situations that calls for it. Okay. So let's not talk about much about therapeutic. Let's talk about intentional and unintentional abortions. So intentional and unintentional abortion speaks of the killing of unborn fetus. So when we say intentional, it's very obvious that the offender willfully and intentionally, deliberately kill unborn fetus. Whether there is a violence or not, whether there is consent or not of the pregnant woman, that is not very much material. Okay? As long as it is done intentionally by the offender, that is considered an intentional abortion. Now, as to whether there is consent or not on the part of the pregnant woman, that there might be considerations on that with regard to the penalty. But again, a few reminders. In criminal law, we should be very careful. If the question is only about the crime, just focus on the crime. If the question is about criminal liability, that is another specific question, which calls maybe for another specific answer. So what we're talking about here now is only about the crime. Okay? So what about unintentional abortion? It is a kind of abortion that can only be committed with violence. Okay? So the abortion is not intentional, but a violence must be inflicted by a person to a pregnant woman. And the said violence must be the one that is intentional, which causes the abortion of the unborn fetus. Okay, so that is unintentional abortion. Remember, violence is an important element. Okay, now what if the victim is already a born fetus or a baby or an infant? Okay, once a child is born, from birth, which begins with the cutting of the umbilical cord up to 2 days old. No, the law said less than 3 days old. Okay, it's not much material as to who is the offender. The issue is the victim again. That is the time that we call for the crime of what? Infanticide under Article 255 of the Revised Penal Code. Again, it's not material who is the offender here. The more material element is who is the victim. The victim must be someone who is born alive, okay, and someone who is below 3 days old or less than 3 days old. So, hindi po kasama ang 3 days. Yung offender might only be considered if we are going to look at the concept of punishment. Okay, because under the law, infanticide does not have a penalty. The penalty for infanticide is taken either from parricide or from murder. Now, that is because now depending on the offender. Okay, so once the victim is already 3 days and above, no abortion, no infanticide, then we proceed down to the next possible crime. Okay, and what is the next possible crime? Now, the next thing that we should look at is there now a relationship between the offender and the victim? Now, here, the victim is still the paramount consideration, but we have to consider now the relationship of the killer to the victim. Okay? Now, if the victim is the father, the mother, or the child of the killer, whether he is legitimate or illegitimate, okay, that crime will not anymore under infanticide because we are talking of 3 days and above. Okay? So in that case, we will go down to the next crime. And what is that next crime? That calls for parricide. Okay? But there are 3 kinds or categories of parricide here. The second one is if you or the killer killed his own legitimate spouse or her legitimate spouse. So either husband killed the wife or the wife killed the husband. Okay? So very clear here, the relationship must be legitimate. So hindi po kasama, we do not include live-in partners. We do not include dating relationship or friends with benefits. Okay? So hindi po yan kasama sa parricide. Now what about in the case of Muslim? If you are Muslim and you are allowed to marry for 3 or 4 wives, then parricide is only limited to the first wife. The second, third, and the fourth wife, if you kill any one of these 3 remaining wives, then the crime is either homicide or murder, depending on the attending circumstances. Now, what is the third type of parricide? That is if the offender kills his other direct ascendants, yun po yung pataas, no? Grandfather, great-grandfather, grandmother, great-grandmother, so on and so forth. Or he or she killed his or her direct descendants. Yun po yung straight downward, no? Yung apo, yung anak ng apo, yung apo ng apo. Yan po ang direct line descendants. But take note, the third category requires that this must be legitimate. Okay? So, legitimate. So, as you can see, in parricide, legitimacy is important except in the case of father, mother, and child. Legitimate or illegitimate can be acceptable. So that's how you analyze the case. Okay? So you begin with abortion. If it is not falling under abortion, go down to infanticide. If it is beyond 2 days, then go down to parricide. Look for the important element. Okay? Now, what if the crime does not fall in infanticide and it does not fall in parricide? Then that's time we go down to another crime. But take note, the crime of parricide is an exclusive enumeration. So what the law specifically enumerate here are the only cases included in parricide. So you do not include brothers and sisters, tito and tita, niece and nephews. They are not included in the enumeration, so they cannot fall under parricide. Okay? So again, if the crime does not fall in infanticide or in parricide, now we go down to the next crime. And what is the next crime? The next crime now is if the killing does not fall under infanticide or parricide, and there is the presence of a qualifying aggravating circumstances, the killing will now fall down to the crime of murder under Article 248. So what is the most important element in murder now? It's not the relationship, but the manner by which the killing took place. Okay? The qualifying aggravating circumstances, we will enumerate those things one at a time later on. Now, if the crime does not involve any qualifying aggravating circumstances, there is absence of qualifying aggravating, and there is a killing, then that's the time we go down to the crime of homicide under Article 249. So as you can see, in cases of killing, the most basic type is the so-called homicide, because there is no need for qualifying aggravating, there is no need for certain age or for certain relationship requirements. Okay? Now, what if there is an intent to kill, but the victim did not die? Then that is the time that we call for the two stages or the two other stages of crime, the so-called attempted and prostrated. Now, it can be an attempted homicide, prostrated homicide, attempted murder, prostrated murder, attempted parricide, prostrated parricide, so on and so forth. Okay? But if there is an intent to kill, but there is no intent to kill, rather, but there was negligence or imprudence and death resulted, the presumption is there is an intent, no? So the crime will fall there on reckless imprudence resulting in homicide. Okay? Resulting in homicide, not resulting to, because resulting to is grammatically wrong. Now, what if there is no intent to kill? Okay, if there is no intent to kill but injuries, were inflicted to the victim, or there are some other form of assault done against the victim, then the crime may either fall now on either illegal discharge of firearm, mutilation, serious physical injury, less serious physical injury, or administering injurious substance or other beverages and others. So that's the time you call for this crime, when intent to kill is not an element. Okay, I hope you follow the proper sequence that will lead you to a better understanding of this crime of destruction of life. Okay, so just an illustration or elaboration. I said a while ago, abortion is committed either intentionally or unintentionally. But careful, you must know the difference between the modes or the manner of committing a crime and the elements of crime. When we are talking about ways of committing, any one of these three constitutes intentional abortion. But when I say element, all of these A, B, C, and D must be present. The absence of one may not complete the crime of unintentional abortion. Okay? So, as I have said, as long as the killing of unborn fetus is done intentionally, let number one, by violence, it is already captured. Without violence, okay? But there is again intention, it is covered by intentional or by acting with consent, even though the pregnant woman allowed such abortion. As long as the abortion is done intentionally, it is covered under intentional abortion. But again, under intentional abortion, the elements now are the following: there must be a pregnant woman, violence must be used against the pregnant woman, and it must be done intentionally. Okay? And as the result of that violence, miscarriage or abortion took place, that is an intentional abortion. So, there is also such thing as abortion practiced by woman herself or her parents, or abortion practiced by physician, those who are in the field of medicine, midwifery, or even in pharmacies, by dispensing abortive substances knowingly. Okay? So that's how you simplified abortion. Okay, I make here again another summary. Okay, so infanticide is here when a child is born and that child was killed before that child reached the age of 3 days. Now, careful, days po ang pinag-uusapan. We are not talking of weeks, we are not talking of months, we are not talking of years. Okay? Because many times in examination, this is given, but somehow the examiner used not days, years, or months even. So there is no infanticide when it comes to weeks, days, and weeks, months, and years. Okay, infanticide is only up to less than 3 days or less than 72 hours. Then parricide, we already discussed, is specifically only covered three. Okay, cases. Murdered, the more important element is the presence of qualifying, aggravating circumstances, and homicide will enter if the qualifying circumstances did not exist and there is a killing. Okay. So this one is just a simple illustration on how we distinguish parricide from murder and homicide somehow. Okay? Those which are lined blue are more of the parricide cases. While those with yellow line, those are the cases, although relatives are involved, they are not included in the crime of parricide. And take note, adopted child are not also included in parricide. Although in civil law, adopted child uh, carries the title equivalent to a legitimate child, but in the crime of parricide, an adopted child who is not really biological child of the adopting parents are not or is not included in the crime of parricide. Okay. So let's have now the circumstances. Actually, the most uh, cases is the so-called murder. Why? Because there are so many ways of committing murder. These are what we call ways or methods. Again, so when we say methods, hindi po kailangan lahat ito. Any one of this enumeration is sufficient enough to qualify the crime as murder. Again, provided the killing does not belong to infanticide or parricide. Okay? Like number one, when there is treachery. Okay? Treachery. That is the use of some ways and means to ensure that you can successfully perpetrate the crime without giving chances to the victim to defend himself. No? Just like when you shot a person who is sleeping, so there is treachery because there is taking advantage, okay, of the situation. The other one is taking advantage of superior strength. If you killed a child who is 3 days old, 4 days old, my gosh, definitely these cannot protect themselves. No, this child cannot protect themselves. So therefore, that can already be qualified as an advantage or taking advantage of superior strength. With the aid of armed men, so it doesn't mean men only. No, armed men here refers to generic term any person that carries a gun. refers to an armament. Employing means to weaken the defense. Like for example, you drunk the person, and after the person get drunk, you kill the person. Okay? Employing means or person to ensure or afford impunity. Like you ask favor for a law enforcer or for any public officer, no, to facilitate or to help you in the perpetration of a crime. That is considered employing means to afford impunity. Okay? The second is in consideration of price, reward, or promise. So dito papasok definitely yung mga killer for hire. So when you hire someone and you ask him to kill somebody and you pay him, the killing is what? Murder. Okay? Then you have by means of inundations, fire, poison, explosion, shipwreck. This is simple. Once the killing involves great destruction or ruin, that will qualify the killing into murder. Okay, imagine you use explosives. Okay, you use motor vehicle, you exploded the vessel. Definitely, it's not only the intended victim that will be affected here. It will cause great destruction and ruin against person and even property. So again, specifically mentioned here, fire. So when you kill a person using fire, that is not an arson because your intention is to kill, not to burn. Okay? The use of poison is murder. But if you poison your father, mother, your child, you poison your wife, you poison your legitimate grandparents, then that is not murder. Why? Because those killings fall under parricide. Even though there are qualifying aggravating, parricide will still be the case, not murder. Okay? Then you have another circumstances on occasion. This is taking advantage of a situation like calamity, okay, earthquakes like a volcanic eruption, cyclone, epidemic, and other public calamities. So those who are taking advantage of situations like this when they commit killing, that is a qualifying circumstances. Okay? And with evident premeditation. What does it mean? Evident premeditation, many people said it is planned. Okay? Actually, the law defines evident premeditation not necessarily as by way of planning, but it is an evidence that there is a determination, okay, on the part of the perpetrator to consummate, to perpetrate the crime. Meaning, he think of committing a crime, there is an evidence that he clung to that criminal intention and he execute that what? That crime. Okay? So it takes a certain lapse of time, no, to consider the concept of evident premeditation to show that the offender deliberately and intentionally perpetrate the offense and he clung to his criminal intention. And the sixth, with cruelty. So definitely, when before killing the person you inflict additional pain, that is cruelty, that will qualify the killing into murder. Okay? Then the other one is by outraging or scoffing on the person. This time we are talking of dead person. So if after you kill the person, you do an outrageous thing, like you cut a portion of the body, you open the body, and you remove the internal organs, or you decapitated the head of the person after killing, those will qualify the killing into murder. So again, if any one of these exists in the killing and the crime does not fall in parricide or in infanticide, then we go down to murder. So for a much clearer understanding, let's have an example here. Okay. A, with intent to abort, gave an abortive medicine to his pregnant girlfriend, causing death of the unborn fetus. What could be the crime? Obviously, this is about unborn fetus, and the crime is done intentionally. So the crime is intentional abortion. What if a certain husband kicked and punched his wife without intention to cause abortion, but because of that violence, it causes death of the unborn fetus? Then this is a clear example of unintentional abortion. Now, what about if A killed the 2 days old son of his sister. Okay, what is the age of the son of his sister? 2 days old. So it is included in the less than 3 days. So obviously, the crime would be infanticide. Okay. Now, what if A killed his father, mother, or child? Legitimate or illegitimate, but already 3 days and above. Oh, that will already be a crime of parricide. What if A killed his legitimate spouse? That is another kind of parricide. And what if A killed his legitimate grandson or legitimate grandparents? That is what? A crime of parricide. Okay? Then, if the killing falls other than this, then we go down to the either homicide or murder. Just like when A killed his brother, sister, uncle, auntie, nephew, or niece, they are not covered by parricide. Then we go down to either homicide or murder. Okay? We prioritize homicide if there is no mention of qualifying aggravating. We go up to murder if there is a qualifying aggravating circumstances. And as I have said, it also includes a killing of an adopted child or an adopted child kills his adopter. As long as they are not biologically connected to one another, they are not covered by the crime of parricide. The crime is either homicide or murder. Now let's have a series of example of murders now. What are the cases of murders? Like 1. X killed B while the latter was sleeping. Now take note, when the examiner used former, latter, whichever or whoever is mentioned first, yun po yung former. Yung huli pong binanggit, that is the latter. So X killed B. Habang si B ay natutulog, that is what? Okay? That is a treachery. Okay? A qualifying circumstances. The killing is murder. Number 2. X killed a child 3 days old. The child is already 3 days old. It is not included in infanticide. There is no mention about relationship, but there is a taking advantage of superior strength. That is murder. 3. X killed Y using fire, motorcycle, or poison. Oh, that is obviously a murder. X with intent to kill stab Y while the latter is passing a dark alley. So this is with evidence of treachery again because the killing took place in a place where it's dark and the victim may not notice the assailant or the perpetrator. 5th, X killed Y in a quarrel, but thereafter cut Y's head. Though this is an example of what? Cruelty or outraging. This is more of outraging or scoffing because the act was done after the person was already dead. 6, X together with Y and Z fired at the house of B, killing B. So that is with the aid of unarmed men. Another case of murder. A killed Y, but thereafter opened Y's body to expose the internal organ. That is another case of outraging and scoffing. X killed a woman, while the latter is a threshold of death. No, habang naghihingalo, X raped the woman. Is that rape with homicide? No. The intention is to kill, not to rape. The rape was only afterthought, so that is still a murder. The rape is the qualifying aggravating circumstances. Okay? X killed Y on occasion of earthquake or other calamity. So this is taking advantage of the calamity or situations. Okay? And another is X while under the influence of drug killed Y. So under Republic Act 9165, the use of dangerous drugs before perpetrating a killing is a qualifying aggravating circumstances. Okay, so I hope it's now clear to everyone the distinction between abortion, infanticide, parricide, murder, and homicide. Okay. Then what is this death and physical injury under exemptional circumstances? This is the case wherein even though the victim was killed or seriously injured, the perpetrator may not be penalized by the penalty provided for the crime of homicide, murder, or parricide, but instead the penalty will only be distierro. Okay, that's why it is called exemptional circumstances. Now, this Article 247 calls only for a two situation. One is the case of a spouse killing the spouse and the paramour or the other person, okay, because the spouse, no, were surprised that his spouse or her spouse is in actual sexual intercourse with another person. So if the spouse killed the spouse and the paramour or the other person, or he inflicts serious physical injury to one or both of them, then the penalty is only distierro. Okay, that is in the case of People versus Abarca. Okay, the second situation is about a parent who is surprised this time by his or her daughter. No, the daughter must be living with the parents and the daughter must be below 18. So it's still not of legal age. So if the father or mother were surprised that their daughter is having sexual intercourse with another person, the father or the mother can kill or inflict serious physical harm, and the penalty imposed by the law is only distierro. Okay, distierro is a restriction of liberty, not less than 25-kilometer radius, but not more than 250-kilometer radius. Now, pursuant to the provision of Article 87 of the Book 1. Now, very important here that we should know that the offender were surprised. No, the offenders were surprised, meaning they don't have a plan. They did not make planning over this. They were surprised that they caught, okay, their spouse or their daughter in the act of having sexual intercourse. Okay, that is the requirements. Now, what is only inflicted is only other forms of injuries like slight physical injuries. Okay, the law said if it is only slight physical injury, okay, he shall be exempt from punishment. So this is an example of absolutory cause. No, absuelto po yung spouse o yung parents kung slight or other form of physical injuries po ang na-inflict doon sa victim. Okay? So here, the crime falls under these situations. Okay? Article 247 is the one applicable. Although, if you kill your wife or husband, that is parricide. Okay? If you kill the other person, that can be homicide. But the provision of Article 247 is the one that will be applied for such a case. Okay, so these are example of the jurisprudence regarding murder cases. I mentioned already about Republic Act 9165. Okay, in the case of People versus Winston Hunt, ito po yung case na pinugutan ng ulo after killing the person, that is murder. In the case of People versus Butler, no, the accused had anal intercourse with the woman after killing. So imagine, after he killed the woman, he committed sodomy, no? Tinira po yung backdoor. So that is considered a qualifying aggravating. In the case of People versus Carmina, she killed the man and she opened the body and exposed the internal organ. That is a qualified, no, a case of murder, definitely. And in the case of People versus Las Pardas, this is our previous example, no, while the woman is at the threshold of death, the perpetrator raped the victim. Okay? So haba pong naghihingalo ay ni-rape yung victima. So these are cases of what? Murder, no, based on criminal jurisprudence. So let's have now the circumstances. Actually, the most cases is the so-called murder. Why? Because there are so many ways of committing murder. These are what we call ways or methods. Again, so when we say methods, hindi po kailangan lahat ito. Any one of this enumeration is sufficient enough to qualify the crime as murder. Again, provided the Then there's also a case of physical injury from a tumultuous affray. You know the problem with tumultuous affray, if there is no eyewitness as to who really committed the killing, then the person who might be held liable is the one who is known to have inflicted the serious injury. But if it is not identified, then that is a great problem, no, in terms of rambulan. Okay? Article 253, oh, this is very simple. It is not a crime to commit a suicide, but a person who gave assistance to the person committing suicide is liable for giving assistance to suicide. Okay? Again, I repeat, suicide is not a crime. And we follow the principle of nullum crimen, nulla poena sine lege. Walang krimen kung wala pong batas na nagsasaad na ito isang krimen. Okay? So, pero yung tutulong sa magpapakamatay, you will be liable under Article 253. So, better, wag nating tulungan magpakamatay. Ano? We discourage them in committing suicide. And next, we have the responsibility of people in duel or duelo. So, ang duelo po, hindi po ini-encourage ng ating batas. Except if it is a case of sports. But if it is not a sports, a duel or duelo po, a combat, man-to-man fight, is not encouraged by the law. It is punished by the law. As a matter of fact, even those who are seconds, yung mga nanonood, mga sulsol, they are also liable under the provision of Article 260. Okay? Okay, this is the part which intent to kill is not an element. Okay? So, ito po yung mga crime na there should be no intent to kill. And what are they? The case of mutilation under 262, the case of serious physical injury, the case of less serious physical injury, and the case of slight physical injury. Now, take note, mutilation, otherwise known as mayhem, is the intentional clipping or cutting either of the reproductive organs or any important part of the body of a person, provided no intent to kill. If the injury causes insanity, imbecility, impotency, blindness, or loss of major senses, or the person were not able to attend to his job or hospitalized for more than 30 days, or it causes deformity or permanent deformity, that is considered a serious physical injury. Okay? Now, if the incapacitation for work or medical attendance is only between 10 days to 30 days, then that will fall now on less serious physical injury. And the lesser crime is slight physical injury, wherein the offended party only incurs certain maltreatments or certain ailment that incapacitated him from work for 1 to 9 days, or he may attend to his work, but there was an injury inflicted to him of a lesser degree. That is slight physical injury. Then we have illegal discharge of firearm. This is the case wherein you point the gun to a person and you fire the gun without hitting the person. And there must be no intent to kill. Okay? Sir, what if I point the gun to the person but I fired it towards another or different direction? That is still an illegal discharge of firearm. Why? Because you point the gun first to the person before you discharge it. That is illegal discharge. Now, if you fire the gun upward without looking on any person at night, that is a case of alarm and scandal. No, that's a crimes against public order. But if you raise your gun and look at a person with a threatening eye or some words, that is more of a crime of threat. Okay? So, very critical po ito, no? Yung illegal discharge of firearm. Now, what about administering injurious substance? Yung pagpapainom po ng mga sustansya or substances na maaaring mag-cause ng injury sa tao, but there is no intent to kill. Is also a crime under Article 264. Okay? So, rape, I think we will discuss rape in another presentations. Okay? Because this is a very, very crucial topic. So, that is only for today. So, we limit the discussion to crimes against person, but we will have a specific provisions or discussion for the crime of rape. I hope that you will wait for that one, and that will be a very interesting topic. Once more, this is Dr. Ariel Dimanlusok, ADMRC Director. Thank you for listening. God bless and keep safe.